know, each side will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. If you'll tell me how much time, if any, you wish to reserve for rebuttal, I'll be keeping time. We've read the briefs and we're ready to proceed when you are.
Thank you, Your Honor. If it pleases the court, the appellant would ask to reserve 5 minutes for rebuttal. My name is Chris Cook. I represent Anthony Horn, the appellant in this matter. Please, counsel, and in this court, I appreciate the opportunity to be heard today. I believe this court, or this case, will present to the court two relatively interesting issues, which for a civil insurance case might not be the norm. The first is the facts of this case present an interesting scenario. And secondly, if this court does not believe that we are successful on the merits of our appeal, there is an opportunity to review the law in the state of Ohio with regard to a trial court's ability to modify an administrative sanction, which I will argue briefly at the conclusion of my presentation. There are three parties in this case that need to be distinguished. The first is a company called Lumberman's Insurance. Lumberman's is an Indiana corporation that issues insurance policies, bonds, and other matters, and pertinent for today, issues bail bonds in the state of Ohio as an underwriter. The second pertinent party is ABC Bonding Company, LLC, which we refer to as ABC. They are an agent of Lumberman's and acted as an insurance agent in the state of Ohio, in the insurance company, at all times pertinent to this case. And the third party is Mr. Anthony Horn, a bail bondsman who was licensed in the state of Ohio to act as a bail bondsman at all times pertinent herein. Sometime in 2012, Mr. Horn approached Lumberman's directly with the intention of entering into a bail bond agreement with them, whereby he would be an agent of them to write and secure bail bonds in the state of Ohio. Lumberman's refused to enter into a contract with Mr. Horn, and that's a significant factor. Lumberman's did not want to do business directly with him, and no contractual relationship was ever entered into between Mr. Horn and Lumberman's. Instead, Lumberman's made a recommendation and said, we have a great company and a great fellow, Mr. Sexton, who is an agent of ours in Ohio, that we will agree to let you be an agent of his, and you can work directly through ABC. So, Mr. Horn,
maybe a sub-agent?
I see it as an agent, direct agent of ABC, because a contract was entered into between Horn and ABC. ABC has its own contractual relationship with Lumberman's. So there's really the Lumberman's ABC contract, the Horn ABC contract. But there's no relation between, or no privity between Horn and Lumberman's. So this relationship begins. Mr. Horn begins writing bonds in the state of Ohio with his license for a few years without incident. Sometime in late 2013, a dispute arises between Mr. Horn and ABC regarding the remittance of certain premiums. There's a dispute to the tune of about $3,700. And Mr. Horn tells ABC, I'll pay you $1,000, but I'm not going to pay the other $3,700 because I don't think I owe it. I think you owe me money. And they go back and forth about this. Ultimately, Mr. Sexton, through ABC, turns over Mr. Horn to the Department of Insurance, where he is sanctioned for failing to remit insurance premiums. A hearing is had, and the hearing officer, after a full testimony and hearing, determines that Mr. Horn should pay ABC the disputed funds of $3,700 and issues a recommended sanction of a 6-month suspension and a civil penalty. Mr. Horn objects. And interestingly, the Department of Insurance changes the payee of that amount, and they do so from making Mr. Horn pay ABC to directing him to pay Lumberman's. Why do they do that? They do that because at the hearing below, Mr. Horn, through his counsel, argues successfully that ABC is not a licensed entity in the state of Ohio to do business, and as a result, had no legal right to A, collect insurance premiums for Mr. Horn at all, or B, enforce the non-payment of a disputed premium. The insurance director recognizes this, and without the argument of any party, changes the order from ABC as the payee to Lumberman's. We appeal, we have a full-blown hearing with the court, and the court, with reservation, sustains the director's findings. The court interestingly notes, however, that had it had the legal ability to do so, it would modify the sanction and order no suspension for many of the factors that the department is supposed to consider, but that are beyond the purview of the trial court.
So how was this issue of ABC not being licensed in the state of Ohio, how was that raised below? Where would we find that having been raised in the record?
There are, the record is rather thick. I don't have it at my fingerprints, but there is argument submitted below in the initial hearing. And I would also parenthetically point out that there's never been a waiver argument of that issue. But in the facts, in the case below, it's argued that ABC is not licensed and that they had no right to demand payment in the first place, let alone enforce the collection of a non-payment.
And you're saying that it was Mr. Horn who raised that?
Absolutely.
Okay.
Yes. As a defense to the claim that he should have to pay any money at all. And again, even the trial court determined that there was a good faith dispute to that non-payment, but again, because of the nature of the current status of the law, the court really couldn't use that in order to determine that the director's decision should be reversed. So what we essentially have is we have an unlicensed company directed to accept premiums, my client ordered to pay premiums to an unlicensed company. And 390518 clearly indicates that it prohibits an unlicensed entity from collecting anything of value or consideration for engaging in insurance activity. Now, the appellees have argued below that ABC didn't really act as an insurance company. They were some sort of a buffer or a managing agent, and as a result, they didn't need to be licensed. That argument is incorrect for two reasons. First, in his deposition, in the testimony under oath, Mr. Sexton clearly says, and I quote, "We act as an insurance agent. We accept your premiums and we are on the hook for 50% of the bond you wrote." That's in the record. I quoted in my oral art in my brief. The principal of ABC concedes that his company is acting as an insurance agent. They're on the hook for 50% of the bond, and they collect the premiums. Mr. Horn never made a single payment to Lumbermans. Every payment was made directly to ABC. So for the state to argue that somehow ABC wasn't really conducting insurance or acting as an agent is just not true. It's not factually accurate. The other issue is ABC, subsequent to this case, subsequent to this filing, went and got licensed. ABC continues to do business today in Ohio, but under a proper licensure. Curious fact that they determined all of a sudden they should get a license after this matter came to light.
So how is that in the record before this court?
It's in the trial court. It's not part of the administrative hearing, but it's in the trial court oral argument because we produced. There's a provision under the law that allows for the submission of evidence at the trial court hearing that was unavailable at the board level hearing. And because they were licensed after the board hearing, that evidence was admissible in the trial court hearing.
And
so
someone testified to that, or there was
no
documentary?
There was a documentary license, the licensure printed off on the state of Ohio's Department of Insurance website. And I don't want to say it was certified or sworn to, but there was certainly no argument as to the legitimacy of it.
Okay.
And again, that statutory section allows it to be introduced because it wasn't available below. So, in any event, what we have here is an order directing my client to pay money to an entity that it had no contractual relationship based upon an underlying obligation that was patently unenforceable. We're asking this court to remand the matter and find in favor of Mr. Horn. I will reserve a few minutes to discuss issues that may be raised, as well as the very interesting issue of why a trial judge could vacate this order and find it wholly inappropriate, but not simply modify the sanction. Thank you.
Good morning, Your Honors. Please, the court and counsel. I'm Scott Myers, Assistant Attorney General on behalf of the appellee, the Ohio Department of Insurance. I think we have to start with a bit of a distinction. There are actually two independent bases to impose liability for the failure to remit premiums, which is the only issue in this case. It was the only issue that was charged in the notice letter. You have a statute which says you have to remit premiums, 3905-14B4. That's what was cited, and that's the basis for the obligation of Mr. Horn. He's admitted that he failed to remit premiums to lumbermans. In fact, the $3,141.50 order of restitution came from Mr. Horn's own calculations that were made at the November 5th, 2013 meeting with Mr. Sexton at a hotel where Mr. Horn voluntarily paid the first $1,000 of what he owed. So we start with the proposition that Mr. Horn has admitted that he owes premium. There's a statutory basis to impose liability. End of case, we're finished. There are no defenses in 3905-14 to a contractual dispute. You cannot contract away your statutory obligation. That's the end of the case. At the hearing, this matter wasn't raised until objections were filed. The hearing was all about a concept of setoff, that Sexton owed Horn money, Horn owed Sexton money, Sexton owed Horn more than Horn owned Sexton, so it's a wash, I don't owe anybody anything. This contract concept didn't come up until objections. That's why we raised the waiver argument. Then if we look at the contract, we keep hearing about no contract between Horn and lumbermans. And in fact, in the opening argument of Horn's original counsel, that's the statement he made. However, by the end of the hearing, Horn admitted that he had a contract with lumbermans. We still don't know to this day what contract we're talking about. And in reality, there are 4 contracts. And I believe, Your Honor, you pointed it out. There is a subagent's agreement. And in that subagent's agreement, that's between Horn and ABC. And the reason for the subagent agreement is that Mr. Horn didn't have sufficient collateral to write bonds on his own. And it's a critical fact here, because a bail bondsman is on the hook for the bonds he writes. If he has a forfeiture because the defendant absconds, the bail bondsman himself has to pay the forfeiture amount. Okay? So he has to have sufficient collateral, and the company will not appoint him without that collateral. Because he didn't have sufficient collateral, the company went to ABC and said, hey, will you loan him some collateral? Will you be on the hook for 50% of his obligation so that he can write for us? Horn said, fine, we will. So we have the subagent agreement where ABC enters into agreement with Horn where they agree to this 50-50 relationship. And these are all contained in States Exhibit H in the record. Then there's a second contract. The second contract is a supervised representative bail bond agreement. And that is between Indiana Lumbermans and Horn. Horn signed that contract. So we've heard and heard and heard Horn had no contract with Lumbermans. That's just patently false. In that, Indiana Lumbermans, the ultimate insuring company that writes the bonds, appoints Horn as their representative, as their agent to write bonds in Ohio. And they actually go on to define the agent, the relationship, as principal and agent. They talk about ABC as a supervisor, which is what he was. And it says the representative, Horn, the agent, will pay premiums as directed by the company. Then finally, we have a supervised representative guarantee agreement in States Exhibit H, which is between Horn and Lumbermans. Again, a second contract directly between Horn and Lumbermans, where it defines this collateral relationship. So what we have here is an insurance company that is ultimately liable for the risk, that appoints Horn as their agent, but so that they have sufficient guarantee of payment, they interpose ABC in the middle as a supervising agent. And what that is a managing general agent. The problem is, it's not a managing general agent under 390572A1, as is cited in the appellate brief. That's the wrong statute. That's a general managing general agent statute, and we've shown in our brief how it doesn't apply. But there is a specific statute, 390583, which is applicable only to bail bondsmen. And it doesn't have all the conditions. It simply says, any person appointed or employed to supervise or manage the bail bond business written by the surety bail bond agent appointed by the company. He supervises. He's a managing director. He's an area director. That's all he is. He supervises the activity of the agent. It doesn't say anything about licensure. It doesn't say anything about anything. It's exactly what was done here, right according to the statute. So the reliance on 390572 is just wrong. Okay? So let's get back to why you have to have a license. You have to have a license in Ohio if you sell, solicit, or negotiate the sale of an insurance product. There's no dispute in this case that ABC never sold bond. What ABC did was they loaned collateral. Mr. Horn did all the selling as the agent for Lumberlands. All ABC did was loan collateral.
That's a term I don't understand.
All right. As I said earlier,
They're a surety for somebody, is that what you're saying?
it's not, I hate to use the word surety because the surety here is actually a Lumberlands. And if, to get out of jail, you must bond. And who is the bond to benefit? And that's the fourth contract we need to talk about. Who is the beneficiary on that bond? It's the court. Because if the defendant does not appear, the court forfeits the bond, the court gets the money. The money comes from the insurance agent. If that insurance agent is unable to pay, that's why we have a thing called a buff account. He has to take part of his premiums by statute and set it into a separate account so that if there is a forfeiture, he has money to draw on to pay the court. He is primarily liable on the bond, the agent himself.
Was there anticipated to be a time where Mr. Horn didn't need the,
The collateral?
yeah,
It's not reflective in the contracts, but that would be typical.
so his buff would get
If his
bigger.
buff account got big enough, he would have sufficient collateral, ABC would probably, but we don't know. That's not in the record. There's no evidence of that, but that would not be unusual in the industry. So,
So what are we to do with this testimony, this deposition testimony of the gentleman from ABC who talks about, well, we took the risks and we shared the
that's
risk.
the collateral.
That's limited to collateral.
Sure. And where this all came about is there was a forfeiture. Mr. Horn had to go and pick up a defendant, and he had to hire a private investigator. He had to incur expenses. And that's where all this originally got started. Because he went to Sexton and said, hey, I've got expenses. You're supposed to pay half of them. Sexton says, okay, give me your half. Well, the Horn half never came over. So it wasn't that Sexton never sold a bond, even though Sexton could have. He's licensed in Ohio. ABC never sold a bond. They just said, okay, because you don't have enough money to pay a forfeiture right now, we will assume 50% of your liability on a forfeiture. We'll put ourselves in the middle. That's what they were paid a commission for. It's just like co-signing a loan. If you were to co-sign a loan for a relative's car and they defaulted, they would go to the relative first and then come to you. It's exactly the situation here. You never bought a car. You just co-signed on a loan. That's what happened in this case. The fourth contract that I think is critical here, that has never been discussed, is the contract with the court. Mr. Horn executed a bond, and those are contained, some examples of those, which point out another problem with this case, are contained in State's Exhibit G. We have a defendant who's in jail. Mr. Horn goes to the girlfriend of the defendant, the indemnity order, posts the bond for him. That bond is written on Indiana Lumberman's post that with the court. If the defendant doesn't show up, the court calls on Indiana Lumbermen's and their agent, Anthony Horn, to pay the forfeiture. Let's follow this case to its logical conclusion then. What Mr. Horn's arguing is, we don't have any contracts, I have no obligation under this bond. Well, what does that mean? That means the court can't call on the bond for a forfeiture. That means Mr. Horn is not willing to stand behind the contract he made with the court. I think it's a fraud of the court. There is of course a bond here. There is of course a contract here. It's between Horn and the court in the endeavor.
And was that argued below?
Never argued below. We've never, the contract that's at issue has never been defined in this case. It wasn't even raised until objections. This whole case was tried on a set-off theory. You know, had I been aware of this argument at the hearing, we could, because Mr. Sexton is calling himself an MGA the whole way through. Because he was an MGA under the bond statute, not under the general MGA statute. And it's really not as confusing as it sounds.
Easy for you to say.
It seems absurd in how confusing this case has gotten. It's really not. Anthony Horn gave the court a bond. He acknowledged that he owed a premium to a company. If you don't pay your premium to your car insurance, they take away your policy. And if you get pulled over, you don't have financial responsibility.
And there was Lumberman's that he.
It was Lumberman's Mutual that is, Indiana Lumberman's is ultimately responsible. They wrote the paper. They are owed the premium the statute says he has to pay. Forget the contracts. It's just that simple. Then you throw the contracts in, you come to the same conclusion. ABC never sold a bond. They loaned collateral. There are 3 contracts, 2 of which are between Lumberman's and Horn that he signed. He does have a relationship defined as agent and principal. Finally, Henry's Cafe. It's a Supreme Court decision from the 50s. It has been affirmed multiple times. I was reminded by the 8th District about 6 weeks ago that they are the only court that's allowed to overturn the Supreme Court. Thank you for laughing. That was a stretch there in an oral argument. I appreciate that. It's black letter law. And I know this judge kind of got off. I think in reality this judge was a little confused about the whole case. I hope I've made it easier. I hope I've made it easy enough that it's obvious that you should affirm the Common Pleas Court's decision. It did not abuse its discretion. Thank you for your time and attention.
Thank you. Mr. Cook, you have 5 minutes remaining.
Thank you, Your Honor. Your Honor, there seems to be, I never question an attorney's statement of what's in the record or what's not. I know the case pretty well. I have never before today heard an issue of a bond written by my client to Lumberman, a bond written by my client from Lumberman's that was part of this case. I don't know where that is in the record. If I'm wrong, so be it, but I've never heard that before. It's not argued in the briefs. With regard to the issue of 3905 requiring payments of premium, end of story, I respectfully submit it's not that simple because 3905.18a requires an insurance agent to be licensed to accept the premium. So how do you square those 2 statutes? How do you read them in peri materia and say you absolutely unequivocally have to pay this premium, but you also absolutely have to have a license in Ohio to act and conduct yourself as an insurance agent or company to collect the premium in the first place? It seems to me that based upon the licensing structure of the state saying we want to have insurance agents licensed to engage in this kind of activity, to collect money, to be responsible for bonds, that the licensing should be a prerequisite to being paid and accepting funds. So I think you have to address those 2 statutes and determine how they can be read together, because if they can't be read together and counsel's correct that the automatic payment of those premiums is required under 3905.13, then what's the point of being licensed? Why would anybody get a license? All they have to do is say, we issued a policy, we're an insurance company, we're engaged in the activity of issuing bonds, so pay us. That can't be right.
Mr. Cook, let me ask you a question. So when Mr. Horn's bond guy, he absconds, okay? And now he has to ante up the money to the court. Where did Mr. Horn get the money from, and where did the money come to pay the court? Did it come from ABC, or did it come from Lumberman's?
I'm not sure if you're asking me hypothetically or if you're asking me specifics.
Well, from what I understood from the appellee, that there wasn't, in fact.
And with respect to counsel, I don't know, I argued this case below, I wrote the objections, I don't know anything about a bond that wasn't paid. I do know
No,
there
I'm not
was
saying it wasn't paid, I'm saying somebody did abscond, and he had to go get somebody.
Okay, that goes back to the underlying, perhaps the underlying reason there was a dispute to begin with and the costs.
Wasn't that what we're talking about, the 31,000?
Well, we're talking about a lot more than that. We're not, counsel's correct, we're not disputing that my client didn't pay the money. He certainly never admitted he owed Lumberman's the money. That was the first thing that's the first argument counsel made. Mr. Horn admitted he owed Lumberman's money. That's not true. He admitted he didn't pay ABC, and he admitted he didn't remit that money because of a dispute, and the court even found that dispute to be legitimate. So we're not suggesting, I'm not sure whether or not there was I don't know the answer to that. My client would have ultimately had to pay the bond, and if he didn't, ABC would have, and if ABC didn't, perhaps Lumberman would have had to stand in ABC's shoes. But the real issue is whether or not ABC had any right to collect money from my client and enforce the unpaid premium. And again, it's never been answered by the state, by the Department of Insurance. Why did the director, on our objections filed below, they weren't waived, why did the director change the order from the payment to ABC to the payment to Lumberman's? The director did that because of our argument that ABC had no right to collect that premium. Otherwise, there's no other explanation for the director of insurance, upon our objections, to change the payee from ABC to Lumberman's. Had he not done that, the director himself, or herself, whoever it is, would have been ordering the payment to an unlicensed entity, and they knew they shouldn't do that. So for no volition, no reason, no argument, no request by anybody, they just make that payment change. And that tells us that there's an issue with this licensure. Finally, I want to briefly address the issue with regard to sanction. Just because a case has been good law for a long time doesn't make it right. We've had a lot of examples in our jurisprudence where cases have been overruled, even very important cases. It is axiomatic that a trial court has the ability to completely vacate an order, to completely overrule an administrative finding, the plenary power to say your decision is dead wrong and it's going to be reversed, but doesn't have the authority to do a lesser act to say, I agree with your decision of a finding of misconduct, but we're going to modify the sanction, a lesser exercise of the court's power. How can that, it doesn't make logical sense. The trial court heard the testimony. The trial court weighed the facts and the evidence. How can the trial court have the ability to completely throw out the case, but not take the lesser action of modifying the sanction? It's just counterintuitive.
You have reached the end of your.
Thank you, Your Honor.
Gentlemen, thank you both for your presentations. The court will take the matter in advisement and will issue an opinion which will be sent to both sides. And do check the Supreme Court website as we post our decisions there. Have a good day.
Thank you.